There are a lot of things that can go wrong in any estate plan. One of those things is incurring extra costs that we can possibly avoid. Hi, I'm John Strohmeyer, and this time we're talking about how we can minimize the future costs of implementing and effectuating your estate plan. Now, as I mentioned, there are a lot of ways things can go wrong. We set up an estate plan and we're basically getting a plane up in the air with a goal of landing at some point a plane where all the assets are there, everybody gets what they want, and there aren't any fights. The problem is a lot's going to happen between now when you sign your documents and when you pass on and we're really implementing your plan without you around. So there are a number of things we want to think about in terms of how we can make it as efficient a process later on. So the number of things we can think about. One of the biggest is, where are the original documents? A lot of times people will think, well, I've got a copy of my will, isn't that good enough? Here in Texas, no, we're going to want to see the original wet ink signature of those documents. There have been a lot of improvements recently in acceptance of electronic documents. We have online notaries who can now allow you to sign those documents from anywhere with that notary being anywhere. But when it comes to last wills, those still need to be physical documents signed with a wet ink pen or a pencil, but we're not going to get into that today, to make sure that we know exactly what that document was. Right now, Texas law is just not set up to deal with electronic documents. Likewise, if you don't have the original document, but you have a copy, that's better than nothing, but it's going to lead to some additional headaches down the line. Why? Again, Texas courts are going to need to see that original document for it to be admitted to probate and to carry out your wishes. The additional cost we're looking at is, if we don't have the original document, we're going to spend more time and effort getting it admitted to probate. Why? Well, if you've got a traditional will and you've got the original and you file it, you don't have to let everybody who would have inherited something from you know about the probate, even if they're not getting something. So imagine you have 3 children, one of them you wanted to cut out for whatever reason, and leave the rest to the other 2 children. If you have the original will, you don't even need to tell that child that's been cut out about the probate. Now, if we've got a case where the original will has gone missing, all we have is a copy, then what we're going to be looking at is that we've got to let that child who's been cut out know about the probate anyway. Now, this can incur additional costs in even just getting to the courthouse before the hearing. The other side of it is that child who's been cut out now knows about the probate, and you're potentially opening yourself up or your estate up for a fight later on. Again, that dealing with the fight later on is a different topic, and we'll save that for a different day. Other ways of making sure that you're minimizing future costs are making sure your documents are actually set up to work in Texas. So we're here in Texas. We have pretty efficient probate process, and I like to tell clients all the time, probate gets a bad rap because of California, New York, and Florida, where probate can be expensive and time-consuming. Here in Texas, it can be less of an issue. But that means that we need to have everything lined up so that it is actually an easy process here in Texas. There aren't a whole lot of things that we need to do to make it easy, but if you don't have them, it just requires more work lining up all the beneficiaries to get an easy probate process. One of those easy things we want to do is have an independent administration. Again, independent administration is one of the hallmarks of Texas probate, and when you've got that, the executor or the administrator gets to operate pretty much free from court control. They'll go ahead and take care of things. They'll file a few documents with the court to let them know what's happened, but otherwise they're really operating without oversight and the required approvals from the court. If you don't have your documents set up to be effective and efficient under Texas law, then you're setting yourself up for getting everybody on board to make sure that the will works. Again, it doesn't mean you can't get this done. It just means it's going to cost you more at the end of the day if your documents aren't set up for Texas. Now, I mentioned Texas, and obviously a word that's spelled like that here are taxes. So we also want to make sure, in terms of minimizing those future costs, have you planned for your taxes? A lot of wills get set up in such a way that they are planned for estate taxes, and given the nature of how the estate tax exemptions have gone up and down over the last 2 decades, your wills may not have the right plan for you. Now, years ago, when the exemption was $500,000 per person, and not the $11.7 million per person it is here in 2021, but you'd leave as much as you could to a family trust, and then you'd leave the rest to your surviving spouse to obtain the marital deduction. Well, a family that had $2 million back then, that would mean that community property means that $1 million belongs to each of the spouses, $500,000 goes in one trust, $500,000 goes to the surviving spouse. In 2021, with an $11 million exemption, that means that $1 million out of that $2 million from the two spouses ends up going to the family trust, and the surviving spouse merely retains their $1 million of assets. So what are we thinking about? It means we want to make sure that the plan works for us. I've seen a lot of wills that were drafted years, if not decades ago, that include tax planning that just doesn't make sense for the family anymore. If you're in a situation where you've got $2 million, 20 years ago, you were in a lot of tax problems and you needed some help avoiding taxes. At this point, you probably don't need to worry too much about taxes because the estate tax isn't going to take that much out of you. The problem and the potential cost for you is going to be minimizing the amount of overhead and work you need to do to avoid funding trusts that you may not need. So again, making sure you've updated the documents to reflect the tax planning, the amount of tax planning you actually need for your documents. Finally, thinking about what assets do you own, and specifically, what's going to happen when you pass. Are you going to need any appraisals? Will your beneficiaries actually be able to own any of these assets, or are they going to incur any sort of costs or compliance headaches when they receive it? What we want to think about is what happens when somebody takes over on this. Are they going to know where and how to find those assets? We'll talk about minimizing loss of assets in a different video, but right now we're thinking about what will it cost in terms of not only legal costs for probate, but in terms of headaches and compliance with any sort of gatekeeper or custodian for those assets. Are you going to need an appraisal? Any sort of thing that could affect the transmission of the asset from your hands to theirs. And so thinking about what those costs are now might help you minimize the costs later. You might be able to figure out what's going on, and so you can minimize the cost by incurring it now, or at least planning for it so you know what needs to be done later. So as we pull this all together, there are 4 big risks to not planning. 1, there are costs, and that's what we've been talking about today. There are also loss of assets, fights, and just other family frustration. We'll talk about those in separate videos. But when we want to think about future costs, we want to think about things that will incur costs for our beneficiaries later on. Do we have our documents set up, and are they actually optimized for the state that we live in? Have we addressed any tax issues? Perhaps we're over planning for taxes and we'll want to unwind some of that planning now before it actually kicks in. Why? If we can unwind it now, we won't need it, and we won't need to plan around it. Finally, what transmission expenses? What's it gonna cost to comply with any special requirements or needs specific to the assets that we have? Thanks so much for watching. If you've got other questions about this, go ahead and leave a question in the comments below. Also, don't forget to like, comment, and subscribe.